The objective of this presentation is to become familiar with the requirements for patentability that are derived from 35 U.S.C. 101. U.S.C. 101 states that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefor, subject to the conditions and requirements of this title. 35 U.S.C. 101 is interpreted to impose 4 requirements. The first requirement is subject matter eligibility. This includes a requirement that the claimed invention must fall within one of the 4 listed categories: process, machine, manufacture, or composition of matter, and a requirement that the claimed invention be directed to eligible subject matter, as these categories have been interpreted by the courts. The second is that the claimed invention must be useful. This means that the invention must have a specific, substantial, and credible utility. The classic example of this is the perpetual motion machine. It is not credible based on our scientific understanding today, and therefore would be barred under Section 101. The third is the basis for the bar against double patenting. The statute says a patent, only one, may be obtained for an invention. An inventor cannot obtain 2 patents for the exact same invention. The fourth is that the patent may only be obtained by the person who engages in the act of inventing or discovering the subject matter of the invention. Pre-AIA, this inventorship requirement was covered by 35 U.S.C. 102F. We will now discuss the first derivation of 35 U.S.C. 101, the 4 categories of invention. These categories are taken right from the statute. As a result, they are often called statutory categories of invention. The statute also recites any improvement thereof, which would thus be an improvement in one of the 4. As we shall see, a process defines steps or actions, whereas machine, manufacture, and composition of matter are all considered products. It is important to identify which category of invention a claim in an application is directed to in order to best understand the meaning of the claim. A process is an act or series of acts or steps, and can include a new use of a known product or a known process. A process claim may also be called a method claim. A machine is a concrete thing consisting of parts or of certain devices and combination of devices. Claims directed to a machine are often called apparatus or system claims. They can include, for example, computers, telephones, vehicles, as well as parts thereof, like a hard drive, a diesel engine, or an automatic transmission. A manufacture is an article produced from raw or prepared materials. Claims directed to a manufacture are sometimes called an article or article of manufacture claim. Examples include things such as a bottle, individual components of a machine such as a gear, and also various forms of computer-readable media, for example, memory chips and recordable disks, carrying functional materials such as software. Plants are also an example of a manufacture. The composition of matter category includes all compositions of 2 or more substances and all composite articles, and can be gases, fluids, powders, or solids. Examples include pharmaceuticals and motor oil. Improvements thereof are directed to improvements in a process, machine, manufacture, or composition of matter. Some improvement claims make use of a particular format. They may start with one of the 4 categories, for example, a machine, Then follow that with a transitional phrase such as wherein the improvement comprises or the improvement comprising, and proceed to describe the features of the improvement. These are called Jepson claims. Note that this is not the exclusive format for such claims. As we will see in further training, note that if an invention is not within one of these 4 statutory categories, applicant cannot obtain a patent on it. For example, a propagating electrical signal, a set of rules to play a game, or a legal contractual agreement between parties would not fit into any of these statutory categories. Thus, none of these examples are eligible for patenting. The second derivation of 35 U.S.C. 101 we will discuss is the utility requirement resulting from the recitation in the statute that an invention be useful. Utility is determined using a 3-pronged test that looks for a specific, substantial, and credible utility. Some examples of subject matter that the USPTO has seen over the years that did not pass the utility requirement include inventions that amounted to perpetual motion, controlling the aging process, changing the taste of food using a magnetic field, and cold fusion. Note that this determination is fact-specific and is determined on a case-by-case basis. If an invention is frivolous, fraudulent, or against public policy, for example, it is illegal or could be considered scandalous or immoral, this alone is not a reason to say the invention is not useful. See your supervisor if you have an application that might include this type of subject matter. The first step in the utility determination is to understand what the invention does when used as disclosed in the application. Applicant is in the best position to explain why the invention is useful, so when consulting the disclosure you may see one or more utilities asserted by applicant, or one or more utilities may become apparent. Now we will look at the 3-prong test for utility. In the first prong of this test, we are looking for a utility that is specific. By specific, we are looking for a utility that is more than a general utility that applies to everything in a broad class of invention. For example, since proteins as a class generally will make bubbles in water, an applicant asserting a particular protein is useful as a shampoo ingredient would not be a specific utility. Similarly, a general statement of diagnosing an unspecified disease without any disclosure of what condition in particular can be diagnosed is not specific. In contrast, a statement of a particular biological activity of a compound, such as acting as a sedative, would be a specific utility. The second prong of the 3-prong test is looking for a substantial utility. A substantial utility would not require carrying out further research to confirm a real-world use. For example, inventions directed to a method of treating a known disease, an assay method that identifies compounds that have their own substantial utility, or an assay that measures the presence of a material that has a stated correlation to the onset of a disease. For example, an assay that measures cholesterol levels as they relate to heart disease would each have a substantial utility. However, basic research on the properties of a product, a method of treating an unspecified disease, or a method of identifying or making a material that has no specific, substantial, and credible utility itself, each would lack a substantial utility, since further research would be required to identify or confirm a real-world use. In some instances, applicants may assert utilities that may appear trivial given the subject matter involved in an attempt to pass the substantial utility prong. These are sometimes called throwaway utilities. For example, use of a new DNA sequence as mere landfill, or the use of any protein as an animal food supplement are throwaway utilities. Further, producing a transgenic mouse costing tens of thousands of dollars to use as snake food may be a throwaway utility. Note also that substantial utility and specific utility often go hand in hand. Since all mice could be as a broad class function as snake food, this is also not a specific utility. However, this analysis depends on the facts of the case. For example, if the transgenic mouse was specifically developed with an enhanced nutrient profile for use as animal food, then this would be considered a specific and substantial utility. The third prong of the three-prong test is the requirement for a credible utility. A utility is credible unless it is either unbelievable or the claimed invention is wholly inoperative. Note that with respect to inoperability, the invention needs to be wholly inoperative. For example, inventions such as a pharmaceutical that is 99% inoperative but can cure 1% of patients having a debilitating disease still has a credible utility. A utility is unbelievable or incredible if the logic underlying the assertions is seriously flawed or the facts on which the assertion is based are inconsistent with the logic underlying the assertion. For example, inventions that violate the laws of physics or thermodynamics, like perpetual motion machines, would have logic that is seriously flawed. Note that a credible utility is assessed from the perspective of a person of ordinary skill in the art and whether they would accept that the recited or disclosed invention is currently available for the asserted use. One of ordinary skill in the art would not accept that a device could be more than 100% efficient and generate more energy than it consumes. Many times, inventions have a specific, substantial, and credible utility that is immediately apparent, well known, or implied by the disclosure, either alone or with the knowledge of one skilled in the art. These are known as well-established utilities. For example, a car, a television, or a cell phone all have well-established utilities and do not require detailed analysis under the three-prong test. Note that well-established utilities do not encompass any throwaway or nonspecific utilities that one can dream up. In summary then, if there is a well-established utility that is apparent from the application, do not reject for a lack of utility, even if there is no utility mentioned by applicant. However, if there is no well-established utility, review the disclosure for any assertion of a specific, substantial, and credible utility. If the asserted utility fails any of the three prongs, then reject the claim as lacking utility and include enough explanation to provide clear facts and reasoning for your determination. The rejection is made under both 35 U.S.C. 101 and 112A as lacking utility and lacking enablement. The topic of enablement under 35 U.S.C. 112A will be covered in detail in another module. Rejection under both sections is necessary because if there is no utility, an applicant has also failed to enable the public to make or use the invention. In order to facilitate the decision-making process for utility, the following slides will walk through the utility decision tree. Begin with identifying the claimed invention and determine if there is a well-established utility for the claimed invention. If there is, then there is no rejection for a lack of utility, and we proceed on to the rest of examination. If there is no well-established utility, then further analysis is required and we proceed with the decision tree. After establishing that there is no well-established utility, check whether applicant has made any assertion of utility for the claimed invention. If yes, we will further test the claimed invention. If no, then without a well-established utility and without any asserted utility, We will reject under both 35 U.S.C. 101 and 112A for lack of utility and lack of enablement because applicant has not disclosed any specific and substantial utility for the claimed invention and provide supporting explanation. With no well-established utility, but an assertion of utility by applicant, we begin the three-pronged test. Here we determine whether the assertion identifies a specific utility. If yes, there is a specific utility, we continue with the three-pronged test. If no, we reject under 35 U.S.C. 101 and 112A for lack of utility and lack of enablement because applicant has not disclosed any specific and substantial utility for the claimed invention, and we provide supporting explanation. Here we continue the three-pronged test on the asserted utility to determine if there is a substantial utility. If yes, there is a substantial utility, we continue on with the analysis. If no, we reject under 35 U.S.C. 101 and 112A for lack of utility and lack of enablement because applicant has not disclosed a specific and substantial utility for the claimed invention, and we provide supporting explanation. Note here that a lack of substantial utility also indicates a lack of specific utility. Here we finish the three-pronged test on the asserted utility by determining if the specific and substantial utility is credible. If yes, the utility is credible, this concludes the utility analysis and we continue on with the rest of examination. If no, we reject under 35 U.S.C. 101 and 112A for lack of utility and lack of enablement because applicant has disclosed at least one specific and substantial utility for the claimed invention, but the assertion is not credible, and we provide supporting explanation. We then continue on with the rest of examination. We will now take a further look at subject matter eligibility, focusing on the court's interpretation of boundaries on the four statutory categories. This is a developing area of patent law. Currently, examination is being conducted using the guidance found in MPEP 2106 as modified by the 2019 Patent Eligibility Guidance and the Office's Berkheimer Policy Memo. You can find the 2019 Patent Eligibility Guidance and the Berkheimer Memo on the 35 U.S.C. 101 Examination Guidance and Training Materials microsite found at the link in this slide. In general, when determining subject matter eligibility, you should first determine what applicant has invented and is seeking to patent by reviewing the disclosure to understand what applicant has invented and reviewing the claims. Then proceed on to determine whether the claimed invention complied with 35 U.S.C. 101. With respect to determining what applicant has invented and is seeking to patent, you should read and understand the complete disclosure and the metes and bounds of the claims. Note that claims define property rights. The property that is encompassed by a claim is based on the broadest reasonable interpretation of the claim in view of the specification and consistent with the interpretation that those skilled in the art would reach. If a claim includes language that expresses a suggestion or something optional, that language may not be a requirement and thus may not limit the scope of the claim. This flowchart describes the process of determining subject matter eligibility. It begins with the critical step of establishing the broadest reasonable interpretation of the claim as a whole before performing the eligibility analysis, because understanding the scope of what a claim encompasses is key when determining eligibility. After determining broadest reasonable interpretation, we proceed to step 1 to check whether the claim is to one of the 4 statutory categories as discussed in earlier slides. A claim will be rejected under 35 U.S.C. 101 if it encompasses subject matter that is not within one of the 4 statutory categories. In general, after step 1, we proceed to step 2A to determine whether the claim is directed to a judicial exception, such as a law of nature, natural phenomenon, such as a product of nature, or an abstract idea. If a claim is not directed to a judicial exception, the claim qualifies as eligible subject matter under 35 U.S.C. 101, provided it is within one of the 4 statutory categories. However, if a claim was found to be directed to a judicial exception in step 2A, we proceed to step 2B to determine if the claim recites additional elements that amount to significantly more than the judicial exception. Even if a claim is directed to a judicial exception, it can still be patent eligible under 35 U.S.C. 101 if there is significantly more than the judicial exception, again provided that the claim is within one of the 4 statutory categories. However, a claim will be rejected if it does not recite significantly more than the judicial exception. Taking a look at step 1 in more detail, we analyze the claim based on the broadest reasonable interpretation of the claim as a whole. The claim must be a process, machine, manufacture, or composition of matter. It is possible that a claim may satisfy more than one category. For example, a bicycle could be considered a machine or a manufacture. If the claim does not fall within one of the 4 categories, it is not eligible for patenting. Consider software by itself. It is not a series of steps, a concrete thing consisting of parts, an article produced from raw materials, or a combination of 2 or more substances. Similarly, transitory signals such as radio waves and humans are not considered to fall into one of the 4 statutory categories. The Supreme Court has further interpreted the statutory categories to exclude subject matter such as abstract ideas, laws of nature, natural phenomena, and products of nature. These are called the judicial exceptions since they were created by the courts and not explicitly enumerated in the statute itself. Abstract ideas include mathematical concepts, mental processes, and certain methods of organizing human activity. Laws of nature include, for example, natural occurring correlations and scientific principles. Natural phenomena and products of nature include that which is found in nature, such as wind or a plant or mineral found in the wild. As seen in the flowchart, even if a claim is within one of the statutory categories, it must still avoid the judicial exceptions to be eligible. In performing the eligibility analysis with respect to the judicial exceptions, in step 2A of the flowchart, we determine if a claim is directed to a judicial exception. This is a 2-pronged test that first asks, in prong 1, whether the claim recites an abstract idea, law of nature, or natural phenomena. If no judicial exception is recited, the claim is eligible. However, if a judicial exception is found in prong 1 of 2A, we proceed to prong 2 of 2A to determine whether there are additional elements recited in the claim beyond the judicial exception that integrate the judicial exception into a practical application. If the additional elements do provide integration into a practical application, then the claim is eligible. Limitations that are indicative of integration into a practical application when recited in a claim with a judicial exception include improvements to the functioning of a computer or to any other technology or technical field as discussed in MPEP 2106.05a, Applying or using a judicial exception to effect a particular treatment or prophylaxis for disease or medical condition, see Vanda Memo. Applying the judicial exception with or by use of a particular machine, as discussed in MPEP 2106.05b, effecting a transformation or reduction of a particular article to a different state or thing, as discussed in MPEP 2106.05c, and applying or using the judicial exception in some other meaningful way beyond generally linking the use of the judicial exception to a particular technological environment, such that the claim as a whole is more than a drafting effort designed to monopolize the exception, as discussed in MPEP 2106.05e and the Vanda Memo issued in June 2018. Limitations that are not indicative of integration into a practical application when recited in a claim with a judicial exception include adding the words apply it or an equivalent with the judicial exception, or mere instructions to implement an abstract idea on a computer, or merely uses a computer as a tool to perform an abstract idea, as discussed in MPEP 2106.05f. Adding insignificant extra solution activity to the judicial exception, as discussed in MPEP 2106.05g, and generally linking the use of the judicial exception to a particular technological environment or field of use, as discussed in MPEP 2106.05h. Examiners should note that Step 2A excludes consideration of whether claim elements represent well understood, routine, conventional activity. The question of whether claim elements represent only well understood, routine, conventional activity is considered at Step 2B and is not a consideration at Step 2A. We reach Step 2B of the analysis only if it is determined that the judicial exception identified at Step 2A Prong 1 is not integrated into a practical application at Step 2A Prong 2. In Step 2B, we then must determine whether any additional element or combination of elements is sufficient to ensure that the claim as a whole amounts to significantly more than the judicial exception. If significantly more is found, then the claim is eligible, provided the claim is also within one of the 4 statutory categories. As shown on this slide, Step 2B includes evaluation of the same considerations as Step 2A Prong 2, plus 2 additional considerations. Adding a specific limitation other than what is well understood, routine, conventional activity in the field, which is indicative that an inventive concept may be present, and simply appending well understood, routine, conventional activities previously known to the industry, specified at a high level of generality to the judicial exception, which is indicative that an inventive concept may not be present. Both of these additional considerations are discussed in MPEP 2106.05d and the Berkheimer Memo, issued on April 19, 2018. As mentioned previously with respect to the 4 statutory categories, claims drawn to humans are not patent eligible. Section 33A of the 2011 America Invents Act codified existing USPTO policy in MPEP 2105 by stating, notwithstanding any other provision of law, no patent may issue on a claim directed to or encompassing a human organism. Note that such rejections are for product claims that are directed to or encompass humans. This type of rejection is not appropriate for process claims that recite the actions of humans. Further, while at first glance, such a rejection might be thought of as limited to the biotech arts, claims encompassing humans can appear in many arts. For example, claims to a combination of a medical device and a patient, a combination of a driver and a seatbelt, or a healthcare network comprising doctors and nurses, these should all be rejected for being directed to or encompassing humans. One special circumstance that would require a rejection under 35 U.S.C. 101 under subject matter eligibility is a use claim. An example of a use claim is the use of a high-carbon austenitic iron alloy having a proportion of free carbon as a vehicle brake part subject to stress by sliding friction. Such a claim is ineligible for patenting because it is not a proper method. Further, such a claim would be alternately rejected under 35 U.S.C. 112b as indefinite because it merely recites a use without any active, positive steps describing how the use is actually practiced. Further training will be provided on 35 U.S.C. 112b with respect to selected issues regarding definiteness and clarity in claims. "35 U.S.C. 101 states in the singular that an inventor may obtain a patent, that is, only one patent. There are two types of double patenting rejections. 1. Statutory double patenting, which applies when the same invention is claimed in either two pending applications or in a pending application and a patent. And 2. Non-statutory type double patenting, which applies when, for example, obvious variants are claimed in either two pending applications or in a pending application and a patent. Double patenting will be covered in detail in further training. "35 U.S.C. 101 states that a patent may be obtained by whoever invents or discovers the claimed invention. Barring evidence to the contrary, the examiner should presume that the inventor or inventors named in an application are the actual inventor or inventors of the claimed invention. In the rare situation that it is clear that the inventorship is incorrect in an application and no request to correct the inventorship has been filed in the application, the examiner should reject the claims under 35 U.S.C. 101. It is recommended that you consult your supervisor or trainer to review any evidence that the inventorship is incorrect before making this rejection. This slide provides MPEP references for further guidance when considering the utility requirement of 35 U.S.C. 101. This slide provides MPEP references for further guidance when considering the subject matter eligibility requirement of 35 U.S.C. 101. You should now be more familiar with the requirements found in 35 U.S.C. 101.